I'm Melody Russell. You're watching Asked and Answered.
Let's actually discuss critical race theory. So you're one of the editor authors of critical race, the book entitled Critical Race Theory, the key writings that form the movement. And this is with let's just name the names. Kimberly Crenshaw is one of them. I mean, you, Gary Peller, Kendall Thomas. I mean, amongst others, like all leading scholars, including yourself. And so, and there's others. But let's just talk about the book in general, like the subject matter and some general takeaways for new readers.
Okay, the first thing is it's important to understand that there are, when you say that there are two distinct understandings of critical race theory. One is the relatively obscure, arcane legal studies scholarship. That is not, it's influential within legal studies, within legal academics as being an a significant effort to examine race in a non-traditional manner as far as legal scholarship is concerned. The other part of it is the invention of right-wing ideologues to find a target to be able to address what has emerged as being a major concern with questions of race, and then within education, an effort to bring America's racial history into the classroom, where it has been largely ignored or consciously excluded from the regular curriculum and the regular classes. So, and as a counter to create a scary, terrible sounding theory that they can attack, they seized upon critical race theory as being a very handy target. And so when people, the legislation, the debates are dominated by the vision, some terrible vague vision of an awful thing called critical race theory. And so that's completely different from the legal studies query that we began with, and we began with it as definitely a political question, but a political question within legal studies, which is not the same as what goes on in the in social media today.
Yeah, but I mean, so in terms of takeaways, though, for people that would,
as far as takeaways for critical race theory, that is to say, the legal studies movement, which then emerged as being a terribly influential, again, primarily in academic circles, is race consciousness. In other words, the question of how and in what way is race to be discussed is important, because it's the primary treatment of race in legal studies is that it's not there. That is to say, it appears only as an historical moment, and after Brown versus Board of Education, and then the Civil Rights Act of 1964, and the desegregation cases, they were interesting, important, but that's old history. And in constitutional law terms, race is limited to a now small corner of equal protection law for strict scrutiny, and it's not discussed. Critical race theory, across a broad spectrum of legal studies, re-raised the question, and it's that whole process of sort of examining what's going on and saying, but there's race here, there's racial issues, there's racial questions, and it's not being discussed. And it's proven to be, it's just raising the question in a systematic way within the particular branch of academics. So there has emerged, for example, within education generally, a major movement calling itself critical race theory in education, along with the broader effort to re-raise the question, to raise and re-raise the questions of race in how, what goes on in classrooms at every level. It's the race, just talking about race, but doing it within the academic, the givens of academics, and criticizing that and saying, well, no, this is what you're suppressing, this is what you're ignoring, and you have to take it into consideration. So
specifically in your particular, your chapter, I mean, let's talk about the article, you know, the critique of the Constitution, you know, colorblind constitutionalism, okay?
Yes.
And specifically you dial right in, you get right into the cases. For instance, you know, you're talking about, for instance, Minnick versus California Department of Corrections, right? And some of the other leading cases in that area. And you're focusing specifically on, you know, the dicta, the comments by Justice Rehnquist, O'Connor. Let's talk about that. Let's explain that article, kind of explain the philosophy around it, and start with that specific thing, and then move into the general, how we use it today, and as we practice and as we try to promote racial justice and you know, justice in terms of gender and justice in terms of the still infancy of the LGBT movement.
The important thing about the article was to critique the idea that our Constitution is colorblind. That is to say that it's possible to have the constitutional cases examine segregation and then desegregation, and that the goal is to somehow reach a situation where we're not considering race, and that the way to do this is to be colorblind. And so one of the first and important critiques is to say, you can't do that. In other words, you can't be colorblind without considering race. And when you do that, you have to take into consideration what's going on. And so there was, for example, in one of the early desegregation cases coming out of, I believe, Florida, where it had been a segregated school system, and the school district, when ordered to desegregate, responded by saying, but we're supposed to be colorblind. We can't figure out who's Black and who's white in order to desegregate schools. That is to say, if we're supposed to be colorblind, well, what are we supposed to do? And the appellate court's response was fairly straightforward. That said, basically, you knew damn well how to create racially segregated schools. You can damn well figure out how to desegregate them. And this is an important part of understanding. When you say you want to be colorblind, it means you have to consider something and then be blind to it. And the important question is, well, what is it that you're ignoring and pretending to be colorblind about? So this is what the desegregation effort was. This was an important part of the consideration, but it remains the same today. That's to say, the basic constitutional doctrine is the Constitution is supposed to be colorblind, and therefore, when we ask, is this discriminatory or not? The starting point is, well, we start with colorblindness. That is to say, everyone is equal, and then is there something wrong with is there any discrimination? When of course the social reality is, and the whole idea of institutional racism is, we don't start from equality. We start from inequality. We start from people being acutely aware of race. And when a court tries to pretend that the starting point is, well, we won't consider race, that's already, the only question is, well, what is it that you've chosen to ignore? What is it that you're suppressing? And then we can have a real discussion about, is this discriminatory? Is this aimed at something racial? What is it that's really going on?
And then if you could expound further on specific cases throughout history. For instance, Bakke, your group talks. I mean, at the time, it's kind of before Bakke, but you've gone back. All of you have gone back and lectured about Bakke, for instance, as one of these cases where you can use the framework that you're talking about to analyze this particular thing. Also, I mean, look, now 2021, we've had some other major rulings. We have issues with voting. We have and we have other movements. For instance, how does that, your article and your framework address, Bostic versus Clayton County? You know what I'm talking about, right? The ruling, the LGBT ruling. Okay, well, anyway, we'll come to that, but
yeah,
we got to. Okay, so anyway, I'll hang up.
Okay,
and let
this is what I suggest. Because, as I said, I've been very general, much more general and abstract than I wanted to be. But a current situation in which the question of race arises, if you can come up with some, so what comes to your mind when I say this is one of those situations? Is there a situation where someone claims that they're not racist, or so if you can give me a specific context, an example.
I'll give you a lot. I could talk about this all day. I'll give you a lot, and people will probably jump in. But let's just start with the fact that after Obama became president, and you've lectured on this as well as your friend Cheryl Harris and Kimberly Crenshaw. After he became president, right, the day before, oh yeah, maybe there was some racial stuff and things were influenced by race. But the day after he gets inaugurated, oh no, we're in a post-racial society. And because we live in a post-racial society, we can't, that's a very subtle way of avoiding talking about race and racial inequities. Right. By the same token, there have been actual, very aggressive ways to wipe out racial questions, such as the last administration's attempt to not do a proper census count. We see it in our work, right? We're on this call with what we do in terms of police misconduct. The big thing that we always want to ask for is we want data collection. We want data collection so that we can show a pattern in practice, with our Monell actions. There was, previous to this, you can even think about pay inequities, right? Gender pay inequities. Don't want to keep the data about it, because if you get data, then you have to address the problem. So anyway.
So this is again an anecdote from a few years back, but Ward Connerly, who was a notorious figure and still is, not well known in California political circles, led an effort to be colorblind. And so first he was about affirmative action, passing initiatives within California to say we should not be race conscious, we should not take racial remediation into consideration for any governmental actions. And then he followed that up with your point, data collection, where he tried to pass an initiative which would ban collecting any racial data, so that, and it was defeated. It was an initiative in California, major, big discussion. It was defeated by essentially a public health argument. That is to say, if we don't collect this data, we are not going to be able to address the real social health concerns. And in the debate, there was the question of, well, should we talk about affirmative action? And the strategy that was adopted was to say, no, we are going to address the way in which, in effect, It was, we address real social issues. So if it's a health question, let's talk about health, and we can't even begin to address the real social issues if we ignore race. And so in public health, this becomes a real issue. More recently, this has become part of the COVID discussions about the fact that it's not necessary to say we're not going to treat poor and minority populations. It's simply, well, we serve who we can, and we're not taking race into consideration. But if you follow the money and you follow where the treatment has gone, it means that poor and minority communities, especially brown and black communities, are bypassed. And it's, if you ask, well, aren't you discriminating? The answer is, no, we never consciously tried to do anything. And so it's a form of colorblind argument. No, we're just doing what we usually do. But if you don't take into consideration, well, that means racial disparities are going to be reproduced and made even worse. So the death rates and among COVID victims is qualitatively higher among Black and brown communities. Then as I said, it's a variation of a colorblind argument. We don't take that into consideration. It just happened that way.
And as a follow-up, since we have at least two new employment attorneys on with us, how does it play out in the workplace? How do we analyze it in the workplace? The de facto segregation, and as you and Crenshaw refer to it as the sort of asymmetrical, kind of approach, the asymmetrical segregation and approach to, color blindness, so that you don't have to address these specific issues.
Well, I'll just talk. There's a moment. Part of this, in terms of the Supreme Court and constitutional history, is to understand and how the court has interpreted Title VII. And here I'll give my short version, and hopefully I won't make too many doctrinal mistakes on Title VII. But there was a moment 20, 30 years ago when the Supreme Court said that if in a workplace there is a practice which has the effect of a disparate impact upon minorities. In other words, there's a practice. So for example, taking into consideration prison records, or taking into consideration standardized tests, IQ tests, and this was a major issue 30 or 40 years ago, that if it has a disparate effect upon a Black population or an identifiable minority population, then the burden shifts to the employer, to the agency that's carrying out the policy, to demonstrate, to show why what they're doing is not a racially discriminatory policy in effect. And if they couldn't show it, then they had to change the policy. Well, the Supreme Court in Washington versus Davis said that for purposes of constitutional law, showing a disparate effect is not enough. That's not enough to trigger any kind of warning. You have to be able to show intentional discrimination. That is to say that the governmental policy or the person involved actually in their mind aimed that policy at a particular racial mind, at a Black person in particular in most of the earlier cases. Well, and then it added in a whole series of tests which made it almost impossible to prove. To be able to show what intentionality was, they made it extremely difficult. So the fact that in a subsidized housing projects, the fact that there was, curiously enough, a disparate effect where minority applicants for housing were not being able to, were excluded from or from housing, subsidized housing, or the location of the project had that effect. The court said basically, no, you have to have proof that the agency intended this to be aimed at racial minorities. And you can't prove it, it's not unconstitutional. And so that this is this kind of way in which the court has taken what for a moment when was looking at institutional racism and institutional practices and said, no, you have to go back and find it and prove it in the mind of someone. And if it's not there in someone's mind, then it's not discriminatory, it's not unconstitutional.
Thanks everyone for watching Asked and Answered. If you like this series, if you like what you've seen and what you've heard, smash that like button and subscribe.